Hi, everyone. Thank you so much for being here today. My name is Elizabeth Chesak, and I currently serve as the president of WDI USA. The topic of today's webinar will be the Ninth Circuit's decision in Olympus Spa versus Armstrong. And our speaker tonight will be Dansky. Just while I'm waiting for everyone to trickle into the room, I'd like to talk about our upcoming convention. So this will be held on September 19th through 21st in Indianapolis, Indiana. It's a 3-day women-only convention. It's a great opportunity to network and learn and share what you're working on. So I will drop that link to buy tickets in the chat below. Alrighty. Sorry, let me pull up my slides. All right, so as I mentioned earlier, tonight's panel is the Ninth Circuit's decision in the case of Olympus Spa versus Armstrong. So on May 29th, in a 2-1 decision of a 3-judge panel, the U.S. Court of Appeals for the Ninth Circuit affirmed a lower court decision that a Washington state law prohibits a female-only spa from excluding men, specifically men who have penises. One judge published a dissenting opinion. WDI USA, which had filed a friend of the court, or amicus brief, before the Ninth Circuit, was not surprised by this decision. And I'll post a link to the brief in the chat as well. WDI issued a public statement about the matter the next day, and I will drop that in the chat as well. So tonight's webinar features Dansky discussing this legal development in the fight for women's sex-based rights. She will explain the lead up to the decision, why the outcome is unsurprising, and what might be next. Dansky is a lawyer, writer, and founder of the Substack newsletter, The Turf Report, and the Democratic Women's Declaration. She has published 2 books, The Reckoning, How the Democrats and the Left Betrayed Women and Girls, and The Abolition of Sex, How the Transgender Agenda Harms Women and Girls. She served as president and member of the board of directors of WDI USA from 2021 to 2024, and as a member of the board of directors of the Women's Liberation Front from 2016 to 2020. She also serves on the editorial board of the academic journal Dignity, a journal of analysis of exploitation and violence. Before turfing herself out of her career, she worked to reform the U.S. criminal justice system, including as senior counsel on criminal justice policy at the ACLU from 2012 to 2014. She has a JD from the University of Pennsylvania Carey Law School and a BA from Johns Hopkins University. So thank you so much for being here tonight, Kara, and now I will mute myself and stop my video, and Kara will take it away.
Thanks so much, Elizabeth, and thanks to everyone who's here. So we're here tonight to talk about the case of Olympus Spa versus Armstrong, what happened and what's next. So first, what is this case? This is Olympus Spa. It's a spa located in Linwood, Washington, which is outside of Seattle, and I have been to this spa. It's meant to be a women-only spa. I went a couple times when I was living in Seattle. I want to say at the outset, this is not meant to be a particularly fancy spa where wealthy women go to get pampered. It's a very community-driven spa where, as you can see in this image, there are many pools. Off to the side, there are saunas, and the women who attend are nude or wearing towels constantly. What you cannot see in this image is that some of the pools have herbs in them that the spa operators think are beneficial for women's bodies for one reason or another. So women who are just post their menstrual cycle are encouraged to be in one pool that is infused with herbs that is meant to be healthy for women's bodies. Post-menstrual cycle, others who are pre-menstrual cycle are encouraged to be in a different pool. So this entire spa is a community-driven spa that is focused on women's health. That's the whole point of it. And it's meant to be exclusively for women. So the spa has been in existence for over 30 years, and it never had a problem. Only women went to attend until 2020, when a man who went by the name of Haven, but whose real name is Caleb, decided that the spa's women-only policy violated his human rights and his rights under Washington state law. And he brought the spa before the Washington State Human Rights Commission. So this is Caleb in 2018. And this is when he was serving on the Seattle Non-Binary Collective, going by Caleb Haven Wilvich, serving as secretary, treasurer, and social media coordinator, they, them pronouns, thank you very much, of the Seattle Non-Binary Collective. But at the time, the Seattle Non-Binary Collective very clearly referred to him as Caleb. And as we can all see, Caleb is quite clearly a man. So Caleb also goes by the name Haven, and Caleb writes a blog called Finding Haven, the gender quest of a non-binary trans woman. Notwithstanding all of this, as we know, Haven, or Caleb, is a man. And he was quite upset that Olympus Spa had a female-only policy, and he decided that this violated his human rights and his rights under state law. So this is another image of Haven, or Caleb, if you like, and this image was published in the New York Post in 2013, after the district court ruled that Olympus Spa's women-only policy did in fact violate Washington state law, and I'll explain why. But I'm just sharing this image because this is Caleb in 2013, after the district court's decision. He is still very clearly man. And so this image is from a Substack post that I posted of the WDI USA statement concerning the case. I can no longer find this social media post of Caleb/Haven Wilvich, but I saw it at the time. And when he won before the district court, he did post this on social media where he said, "I did it. I got the main naked lady spa in the area to change their policies and allow all self-identified women access regardless of surgery and genitals." Exclamation point, excuse me. "I'm more woman," he said, "than any TERF will ever be, because I am an intentional woman, whereas they are only incidental." So this is Caleb/Haven Wilvich, as reported in the New York Post, bragging on social media that he essentially forced a women-only community spa that is fundamentally about women's health to admit men, including men who still have their penises. Now, I will pause to just say that disappointingly, at some point during these proceedings, the spa changed its policy to allow so-called post-operative trans women into the spa. Now, we all know that what post-operative trans women means is men who have had their penises removed. I wish the spa had not conceded this. However, this spa is owned by the adult children of Korean American immigrants. The current owners are first-generation Korean Americans. They are practicing Christians, and their parents immigrated here from Korea. And even though I don't like that the spa changed its policy to allow men who have had their penises removed, I also do understand that the spa was under tremendous pressure dealing with an unbelievably confusing situation where this white dude with a penis had dragged them before the State Human Rights Commission, and they were essentially bullied into changing their policy by the Washington State Human Rights Commission. We'll get into that a little bit more. But the point of this slide is just to show that Mr. Wilvich was quite pleased with himself for getting the quote unquote main naked lady spa in the area to change their policy and allow men with penises into the spa. Okay, so what happened before the Washington Human Rights Commission and the District Court for the Western District of Washington? The Washington Human Rights Commission is a state agency. It was set up in order to evaluate claims of discrimination under Washington state law. Fair enough. The District Court for the Western District of Washington is a federal court. So what happened is that Mr. Wilvich brought the spa before the Washington Human Rights Commission and argued that the spa was in violation of state law. The Washington Human Rights Commission ruled in Mr. Wilvich's favor and said that, yes, in fact, the spa was in violation of Washington state law for refusing admission to men with penises or post-op or preoperative transgender women. And in turn, the spa turned around and filed a federal lawsuit in the District Court for the Western District of Washington against the Washington Human Rights Commission, which I think is a pretty bold move. And the first complaint that the spa filed in the District Court for the Western District of Washington was dismissed. They filed an amended complaint, and that was dismissed as well. And the main claims that the spa brought by counsel, by their lawyers, were First Amendment claims. And I'll get into that a little bit. But the point for purposes of this slide is that both the Washington Human Rights Commission and the federal court, the District Court for the Western District of Washington, agreed that Olympus Spa was in violation of state law for excluding men with penises from a female-only naked spa. Okay, so this is the law in question. You don't have to read all of it. The point that I've highlighted is that Washington state law prohibits businesses and other entities from discriminating against people on the basis of sexual orientation. Now, on the face of it, that's a really good thing. It means that businesses like restaurants, bars, movie theaters, etc., are not allowed to discriminate against people on the basis of sexual orientation. That's great. It means that businesses aren't allowed to discriminate against lesbians or gay men, which is awesome. To the best of my knowledge, the spa has no history of discriminating against lesbians. Its women-only policy accommodates women of any of three sexual orientations: heterosexual, homosexual, and bisexual. I'm not aware of any complaint that has ever been brought by a lesbian against the spa for discriminating against her on the basis of her lesbian sexual orientation. So this is the state of the law in question. And so Mr. Wilvich claimed that the spa discriminated against him on the basis of his sexual orientation. Why? How was he able to get away with that? Because another provision of the same law says that under Washington state law, sexual orientation means heterosexuality, homosexuality, bisexuality, and gender expression or identity. And Mr. Wilvich claims to have a female gender expression or identity, even though he is quite obviously male, whether or not he has a penis. And to be clear, at the time of the litigation, he did, but I've been told that he has since taken steps to remove it, which is weird. I don't understand that. But regardless, it doesn't matter. Caleb Haven Wilvich is a man, and he was allowed to bring Olympus Spa with its female-only policy to the Washington State Human Rights Commission, and later to the District Court for the Western District of Washington, arguing that the spa discriminated against him on the basis of his sexual orientation because he claims to have a woman gender expression or identity. If any of this seems confusing, that's because it is. I don't know anything about Caleb Haven Wilvich's actual sexual orientation. I assume he's straight, but I don't know. But there's just literally no indication that anyone discriminated against him on the basis of his sexual orientation. The spa discriminated against him, I would argue lawfully, because he's a man. But this is how Washington state law is structured, unfortunately. Okay, so this is a paragraph from the district court's decision in favor of the Washington State Human Rights Commission. Remember, the first step of this case was that Wilvich brought the spa before the Washington State Human Rights Commission, which ruled in Wilvich's favor on the basis of Washington state law. And then the spa sued the commission in federal district court. And the district court ruled in favor of the commission on the basis of Washington state law. Now, I have been doing this for 10 years now. As Elizabeth mentioned, before I was working with WDI USA, I served on the board of the Women's Liberation Front from 2016 to 2020. And in the course of those 4 years, I worked on every single friend of the court brief, also known as an amicus brief, that Wolf filed in federal court. At the beginning of all of this, it was very frustrating to me to see federal courts use a phrase like transgender women. Now, because I hate that phrase, I will never use it. WDI USA will never use it. It was very frustrating in the first couple of years to see the phrase transgender women show up in federal court documents. However, at years into this, I've gotten to the point that I can see the phrase transgender women be included in court documents without becoming enraged. I just had to get over it and accept that that's what was going on. I'll keep fighting it, but at least I can read the phrase transgender women without going into a complete rage. This one was new to me. I've highlighted these phrases. They're not highlighted in the court opinion. I did that for purposes of this slide. The phrase transgender women with male genitalia was brand new to me. I had never seen that before. This is in a published opinion of the District Court for the Western District of Washington, which is horrible and very depressing. So when I read this phrase repeatedly and uncritically throughout the decision, I again became enraged. But that's okay. Moving on. Okay, so Wilvich, on the basis of his woman gender expression or identity, won before the Washington State Human Rights Commission, and then the Washington State Human Rights Commission won before the federal district court. The SPA then appealed to the Court of Appeals for the Ninth Circuit, which is where we've been since early 2024. And WDI USA filed a friend of the court brief in support of neither party. And that's kind of important here for thinking about what comes next. Traditionally, when an organization files an amicus brief in federal court, you file it in support of one or the other party. In this case, we made a strategic decision. I should say the board at the time, which included me, made a strategic decision to file in support of neither party. And we did that for a couple of reasons, which I'll talk about. Okay, so this is the cover page of our brief, which is very fancy. It's not really very fancy. This is a very normal cover page for a brief that gets filed in a federal appellate court. Okay, so these are the arguments that we made. And I apologize for the legalese here, but it necessarily includes legalese because in this particular brief, we're talking to judges, right? We're talking to a federal court of appeals. So the first argument, and probably the most important one legally, is that if the WLAD, which stands for Washington Law Against Discrimination, elevates, quote unquote, gender expression or identity over sex, it violates the Equal Protection Clause of the 14th Amendment. I think that's critical. And in my capacity for a while as president of WDI USA, WDI USA has tried on multiple occasions to get this argument before the federal courts. We want the federal courts to engage with and really take on the argument that letting men into a female-only place of public accommodation, whether it's a spa, whether it's a women's bathroom at a restaurant, or a women's bathroom at a movie theater, or whatever, I really want the federal courts to engage with what I consider to be a very important argument, that state laws, like Washington's law, that let men into female-only spaces actually violates women's rights under the Equal Protection Clause of the 14th Amendment. So we put forth that argument here. But also, I found sections of the Washington Law Against Discrimination that exempt lawful business classifications that are based on sex and necessary for sexual privacy. Now, in researching this brief, I could not find any indication in the state legislative history as to what the legislature might have meant by exempting lawful classifications that are based on sex and necessary for sexual privacy. I have no idea what the Washington legislature meant when it included those exemptions. And I have also found no case law in state courts or in the federal courts about what those provisions mean and whether they might actually protect the spa in this case. So we argued to the Ninth Circuit that the Ninth Circuit should really consider those and tell us what they mean and whether they can save the spa's female-only policy. So that's the first main argument we made. The second two arguments were more policy arguments than legal arguments, but they're really meant to make the Ninth Circuit think about what's going on here. So our second argument was that Washington State cannot, as a practical matter, enforce both the gender expression or identity provision of the Washington Law Against Discrimination and its criminal laws prohibiting voyeurism and indecent exposure. And in this section of the brief, we explained what voyeurism and indecent exposure are. Voyeurism essentially is, peeping, leering sexually, inappropriately, without consent at another person. And indecent exposure is essentially, exposing yourself indecently and sexually in a manner that is likely to cause concern. Washington State defines these crimes similarly to how many other states define these crimes. There's nothing unusual about Washington's law concerning these two criminal offenses. And I've just never been able to figure out in my mind how any official thinks that a state can, under civil law, let naked men into female-only naked spaces and also enforce its own criminal laws. So we put that argument before the Ninth Circuit. And our third argument is an argument that WDI USA has made in pretty much every amicus brief that it has filed before federal courts at any level, whether we're talking about a district court, an appellate court, or the Supreme Court, where we argue that the term transgender and other related phrases is a linguistic sleight of hand that obscures the material reality of sex and entrenches regressive sex stereotypes. So we went into that in some detail in this brief. Okay, this is the concluding paragraph of No, this is not the concluding paragraph. This is a paragraph that is included in argument 3, where we're criticizing the district court for using terms like transgender uncritically and without definition. So I just have to tell you that when I was sitting there reading the district court's decision that included the phrase transgender women with male genitalia, I just couldn't believe it. And very unfortunately, I realized that in order to explain why this is a problem, I was going to have to cite a definition of male genitalia, which I promise you, Googling definitions of male genitalia is not something I ever wanted to do, but there I was doing it. And I found a credible definition in the NIH that explains what male genitalia is. It basically is just a list of organs. I can't believe I had to Google this, but I did because I had to cite something. So I cited the National Institutes of Health and dropped a footnote. And as I was doing this, I just thought, why is this even necessary? Like, why do we have to explain to the United States federal judiciary what male genitalia is? This is insane. And so I found myself writing, at no point did the district court explain how individuals with male genitalia can be a type of women. It goes without saying that women do not have any of these organs. And then I just found myself writing the sentence, it is truly a testament to where we are as a society today that it must be said in the context of federal civil rights litigation that women don't have penises. Like, I don't understand why it falls to feminists to explain to the federal judiciary that women don't have penises. And shortly after this brief was filed, I wrote an article in which I said something like, if you had told me when I graduated from law school that I would one day be using my law degree to explain to the United States federal judiciary that women don't have penises, I would not have believed you. Nonetheless, here we are. So that was a paragraph that appeared in the WDI USA amicus brief. This is the concluding paragraph and why the board chose to file in support of neither party. And here's the gist. The first sentence of this is that if the district court correctly interpreted state law to mean that any men can access any women-only space in a place of public accommodation like the spa over appellant's First Amendment objections, then it should affirm the district court decision. And my thinking here, and the board's thinking, was Washington state law on this is so bad, as is California state law, and now New York law, and many other state laws. They just open the doors to letting men into female-only spaces. And given that, maybe it's time for the judiciary to just say, look, this is not a problem for the judiciary to solve. This is a problem for the state legislatures to resolve. So that's part of why we didn't file in support of the spa, even though we support the spa's female-only policy. And we would prefer that the spa excluded all males, including males who have had their penises removed. Okay. But we also noted in our concluding paragraph that the Washington law against discrimination has provisions that exempt lawful classifications that are based on sex and necessary for sexual privacy. And we thought maybe those would save the spa's single-sex policy. And then finally, we said that none of the arguments that we put forth in our brief were even pled by the spa's lawyers in the lower court. So one option, and the option I really wish the Ninth Circuit had taken, would have been to send the case back to the district court to conduct what's called a de novo review of our arguments. De novo just means from the beginning. As I mentioned earlier, I'll get into this a little bit more. The only arguments the spa's lawyers put forth were First Amendment arguments, and in my view, bad ones. So what we wanted was for the Ninth Circuit to send the case back to the district court and say, listen, district court, here are some interesting arguments about the Equal Protection Clause of the 14th Amendment. Here's some interesting arguments about women's rights. Here's some interesting arguments about how can a state enforce both the law against discrimination and criminal laws against voyeurism and indecent exposure. Here's some interesting arguments about the use of language. We really wanted the Ninth Circuit to send the case back to the district court and tell the district court to engage with our arguments, but they didn't do that. Instead, from my point of view, we didn't lose, in part because we weren't a party, but also in part because we filed in support of neither party. So we were kind of like, okay, let's see what the Ninth Circuit does with this. We couldn't lose. However, the SPA did lose because, as Elizabeth said, there was a 3-judge panel that voted 2-1 that voted in support of the Washington State Human Rights Commission, which means that the SPA lost and the SPA has to accommodate men to be allowed to enter a female-only spa on the basis of the men's gender identities and expressions. In my view, the SPA lost for 2 main reasons. The first reason is that the Washington law against discrimination is horrible. Again, it defines the phrase sexual orientation to include gender expressions and identities. That is an absolute disaster for women and girls as a sex class. It is a particular disaster for lesbians. The second reason the SPA lost is that I really think that the SPA's lawyers presented losing First Amendment arguments. I can get into those in the Q&A if you would like to know what First Amendment arguments the SPA's lawyers presented and why I think they were so bad. Now, this was a 2-1 vote, which means that 2 judges voted to affirm the district court in favor of the Washington State Human Rights Commission, and 1 judge did not. The 1 judge who did not is a judge named Judge Lee, and he issued a dissent. And that's a good thing from the perspective of WDI USA. However, disappointingly, in my view, the judge didn't engage with our arguments either. And I don't like the dissent very much because the SPA's lawyers, again, presented First Amendment arguments, which the 2-judge majority very easily dismissed because they were terrible arguments. And the dissenting judge, Judge Lee, didn't engage with those at all. Instead, Judge Lee came up with what I think is a very tortured interpretation of the law against discrimination. And he also went on a bit of a political screed, I think, because Judge Lee is a Trump appointee. And Judge Lee accused the Washington State Human Rights Commission of essentially hating Donald Trump, which, to be clear, they do. The Washington State Human Rights Commission has a lot of things up on its website about what a horrible person they think Donald Trump is. Okay, fair enough. But the problem, in my view, with Judge Lee focusing on that in the dissent is that that's totally irrelevant to how the district court decided this case. So I'm very disappointed in the dissent because, in my view, our brief gave Judge Lee what he needed to issue a very strong dissent, and he didn't do that. So I'm frustrated with Judge Lee, even though Judge Lee very clearly wanted to rule in favor of the SPA's female-only policy, which I appreciate, but I don't think he presented effective reasons why the court should have gone that way. Okay, so what's next? So I have been in touch with the SPA's lawyers, and their intention, this is all public, I'm not revealing anything secret, their intention is to file what's called a petition for rehearing. They're going to file 1 petition for rehearing, and they're going to ask for either a petition for rehearing before the original panel, the 3-judge panel that decided this case, or a rehearing before the entire Ninth Circuit, which is called en banc, but the full court consists of something like 30 judges. So if they get rehearing, before the panel, that will be one thing. And if they get rehearing before the full court, that will be kind of a different thing. And if all goes as planned, WDI USA will be filing a friend of the court brief in support of their petition for rehearing. As mentioned previously, our amicus brief was filed in support of neither party for strategic reasons, which I hope I've explained clearly, but if I haven't, definitely ask in the Q&A. This time, the plan is to file a friend of the court brief in support of the SPA's petition for rehearing, because we want this case to be reheard. And so our position on this very narrow issue of whether the case should be reheard is that yes, it should be. And so I think that the WDI USA board is comfortable with the friend of the court brief filed in support of the SPA's petition for rehearing. So that's where we are. I'm going to stop my screen share. And I'm happy to take any questions that there might be. I don't know if Elizabeth is going to read questions or if you want me to check the Q&A box, which I'm happy to do.
Yeah, just a sec here. I'm unmuting myself. Thank you for that, Kara. That was great. All right. Yeah, Deb Hornstra would love to hear more about those losing First Amendment arguments. What were those arguments?
Okay, so one of them was freedom of speech. A second was freedom of religious, freedom of religious exercise. Sorry. And the third I'm blanking on, but I'll think of it while I'm talking about the first two. The first argument was that the Washington State Human Rights Commission unlawfully forced the SPA to change its signage and website to reflect its position. I should have said, in the course of the litigation, after the Washington State Human Rights Commission essentially bullied the SPA into allowing men without penises into the SPA also agreed to change its position to allow men with penises, i.e. preoperative transgender women. The SPA agreed to allow such men into the SPA pending litigation. And the State Human Rights Commission said, okay, well, great, from their perspective, now you have to change your website and signage. And so one of the SPA's arguments is that for the State Human Rights Commission to force it to change its website and signage violated its First Amendment right against compelled speech. And what the majority of the three-judge panel said was, no, the SPA already agreed to allow preoperative transgender women in pending litigation, and therefore all the State Human Rights Commission did by saying, okay, great, change your signage and your website, all it did was tell the SPA that it had to, change its website and signage to align with its own agreed upon policy pending litigation. I think the majority of the Ninth Circuit got that one right. The second First Amendment argument was free exercise of religion because the SPA's owners are Christians. And I fully support the free exercise of religion. I don't happen to be a Christian or a religious person at all, but I fully support the rights of anyone to practice and exercise whatever religion they have. And I fully support the SPA's owners' right to freely exercise their religion of Christianity. But what the Ninth Circuit majority said was, that's fine, but the SPA itself is not a religious institution. The SPA itself is a business. Hundreds, if not thousands, of people go in and out of the SPA every day. No one knows anything about their religious affiliation. So even though the SPA's owners are Christians and they absolutely have a First Amendment right to exercise their religion, that doesn't mean that they have a free exercise right to do something that violates state law. I hope that makes sense. I thought I would think of the third one while I was talking about that, and I haven't, but I probably will, hopefully will.
Thanks. And I do recommend that everyone check out the link of the recording of the oral arguments back from last November. It's just really something else to be in that courtroom as they started up. All right, Natalie Andert wants to know. Well, I guess maybe we should answer Deb's follow up comment to her question. She says, "Isn't that similar to the bakery that didn't want to bake a gay wedding cake?"
Yeah, yes. I mean, I think it's similar and different, but I am less familiar with that case than I ought to be. In my view, the wedding, so one thing that differentiates the wedding cake case from this case is that the reason the Supreme Court ultimately ruled in the way that it did is that the Colorado State Human Rights Commission in that case demonstrated a very obvious bias against the cake baker. So that's arguably a difference between that case and this case.
Thanks. Okay, the question to know if there's any petitions or emails we can send to push for this rehearing.
No, because courts are not like elected officials. So courts are not supposed to be swayed by public opinion, unlike elected officials. Of course, judges have their own biases and they often are swayed by public opinion. But no, it would be inappropriate to have any sort of petition campaign. But if you want to donate to WDI USA to help strengthen the amicus brief in support of rehearing, that would be great.
We always appreciate that. Forrest Rom would like to know, what about the employees essentially being forced to provide hands-on services for nude men? Isn't that a violation of their religion?
Well, I mean, it's so what about the employees? One service that the spa provides is extremely intimate body scrubs. I have had this body scrub, and there's really no way to explain just how intimate these are. If you ever have one of these body scrubs, you will come to be familiar with parts of your body that you may never have known existed. These are performed by women who are trained to perform these body scrubs on female bodies. Doesn't matter whether it's an older female body, younger, taller, shorter, larger, smaller, whatever religion, whatever skin color, doesn't matter. It just has to be a female body. It is absolutely disgustingly inappropriate to expect these women to perform these intimate body scrubs on male bodies. It's just disgusting. Does it violate their religious rights? I don't know, because I don't know the religion of any of the employees.
All right, Crystal Brown, oops, I lost track of her question, she asks, would the spa consider getting a different lawyer, or would he likely revise his arguments if given a new hearing?
I have had a conversation with the spa's main lawyer and look forward to continuing to have conversations with him about those questions.
Pippa Breakspear would like to know, why did the courts appear to be so captured by gender ideology? For instance, the overt display of the progress flag.
So I don't know, I don't have any personal knowledge to answer that question, but I can say that a woman named Elspeth Cipher is a retired judge, state judge, I think in Massachusetts. And she's currently working with Women's Liberation Front. And she tells me that judges, at least on the state bench, just receive training after training in how to refer to people using their preferred pronouns, how to use language to go along with gender identity. I know that the American Bar Association is completely captured. I know that the American Bar Association has completely captured law schools. So the entire legal profession is just as captured as anyone else, including the judiciary. Including, by the way, judges appointed by Republicans. So I wrote recently about a different case coming out of the district court the appellate court for the DC Circuit, an opinion written by a judge who was appointed by Ronald Reagan, which kind of blows me away. I don't know how many judges are currently on the bench who were appointed by Ronald Reagan in the 1980s, but apparently there are some. And this particular judge issued an opinion that was just filled with transgender language.
Yeah, Ruth Perkins says Jamie Reed, whistleblower from St. Louis, said she used to train judges in this BS.
Yeah.
All right, I think we have another question coming
If
in.
there's anyone from WDI USA who can remind me of that third First Amendment argument that they put forth, it's in our statement. I'm spacing and it's really bothering me that I can't remember. If anyone can remind me and put it in the chat or something, I'm happy to address it.
I'm spacing too. I'll take a look at the statement. So we have an attendee who only goes by A, says, as an employee, can I claim servicing men goes against my religious beliefs without stating my religion?
I don't want to get into any like specific questions that would require me to provide legal advice to any individual.
That's fair enough. And she says she understands. So I have a question. Oh, we have another one coming in. Oh, it was a comment. So I had a question. Could you tell our audience what might be a likely outcome for the spa? Will they likely close over this decision?
Oh, I mean, so that's another whole set of factual questions. I have no idea. But as many people have said, as this case is being discussed, women are going to self-exclude. Women are not going to go to what they expect to be a female-only spa if men are allowed to walk around there naked, whether or not they have penises. So I just want to note, Carrie has helpfully yes, okay. Carrie has helpfully put in the third First Amendment argument that they argued, which I can address. But I don't know what will happen with the spa. I do know that the night before oral arguments in the case, WDI USA held an event at the Seattle Public Library, which was well attended, and it was quite a wonderful event. And a woman from the Korean American community in Seattle talked about how important the spa is to Korean Americans in the Seattle area. It's not limited to Korean Americans, obviously. Any woman of any religious, ethnic, racial background can go. But it is really, it's grounded in Korean traditional culture. And it's important for Korean American women in the Seattle area to be able to go there as often as they can. Obviously, everyone can't afford it all the time. But if you can afford to go once a month or once every 2 months, it's delightful for women to go and engage in practices that are good for women's health and to be a space where women can just communicate and be in physical presence with one another. So it's really devastating to the community of women in the area. Will they shut down? I don't know. I don't know. We'll see what happens. I'm guessing probably not, as long as they can remain in business while this is all pending. I'm guessing and hoping they remain in business. So thank you, Carrie. The third First Amendment argument had to do with freedom of association. This is an argument where certain entities have a First Amendment right to freedom of association where they are allowed to exclude people. And as a women-only organization, we should probably think that's a good thing, that we have a First Amendment right to exclude men. But the two-judge majority of the Ninth Circuit ruled that the spa doesn't qualify for that exemption. There is a state law on the books that says that you're not allowed to discriminate against people on the basis of sexual orientation, where sexual orientation includes gender expression or identity. And again, the spa is not a quote unquote intimate association. And by intimate there, they don't mean like intimate in some romantic or sexual way. They just mean that organizations that are allowed to exclude people in violation of state law, or at least organizations that can be exempted from these kinds of state laws on the basis of the First Amendment right to association, have to be small, intimate associations. So I would argue, for example, that if a man ever applied to become a member of the board of WDI USA, I would hope that the board of WDI USA would have a First Amendment right of association to exclude men. But a spa that has hundreds or thousands of people coming and going every day does not meet that.
All right. Jess Grant would like to know if a man has ever actually entered the Olympus Spa. Yeah, refresh my memory. Did Caleb or Haven Wilvich actually visit the spa?
At the beginning, no, he was not actually even excluded from the spa. He just filed a complaint that their women-only policy violated his human rights. Has he ever visited the spa? I don't know. I don't know if he has ever visited the spa. I don't know if any man has ever visited the spa.
All right. Mario Lutmore asks, is this going to be petitioned to the U.S. Supreme Court?
We'll see what happens. So the panel, the Ninth Circuit panel and the Ninth Circuit full court can both decide not to rehear the case. They can decide to rehear it if they want, or they can decide not to rehear it. If they decide not to rehear it, then the spa has the option of asking the court to review it. And then the Supreme Court has the option of saying yes or no to that question. If the Supreme Court takes it up, that'll be another layer of argument. If the Supreme Court doesn't, then the Ninth Circuit panel decision stands.
We have a question from an anonymous attendee that says, hypothetically, if an employee had a formal diagnosis of PTSD due to sexual trauma, wouldn't forcing them to perform these services on men be a violation of the ADA if they found it re-traumatizing?
I don't know. I think it would be horrible, but I don't know if it would be a violation of the ADA. I'm not an expert in ADA law.
Okay. So, Mario Lotmore says, are there any similar cases in the US, and if so, where? So just off the top of my head, this reminds me strongly of the Jonathan Yaniv case, better known as Wax My Balls. He's a white dude who pretends he's a woman, and he sued multiple immigrant women for refusing to provide their services to him.
In Canada.
In Canada, yes.
So this is a question about the US. So there's the We Spa case, of course, where a man named Darren Marager, I don't know how to say his last name, in 2021, I think, entered the female-only section of a Korean spa in Los Angeles, and nudity is expected. This is, again, a traditional Korean spa. And in places where nudity is expected, patrons are separated by sex. And Darren entered the female-only section of the nude spa, totally naked, or he got naked, and he sat down on the on a jacuzzi with his legs open and everything right out there. And surprisingly, somewhat in today's environment, he was actually charged with indecent exposure. And very recently, he was acquitted on all 9 counts of indecent exposure. Lisa H is saying it's happening here too. I don't know where Lisa lives, but yeah, it's happening everywhere. It's happening in California. I know from the group Women Are Real that several supposedly female-only spas are being invaded by men who claim to have women gender identities.
All right, I think our questions have trickled to a stop, and we are almost at the hour mark, so we'll wrap up soon. Thank you all so much for attending, and Kara, thank you so much for breaking down the case, its outcome, and the implications.
Absolutely. Someone's pointing out in chat that the guy who invaded the female-only section of We Spa turned out to have priors. That's absolutely true. He did multiple priors.
Gee, I'm so surprised.
I know.
Anyway, thank you all for attending, and we'll see you next time.
Thanks, everyone.